In March 2015, the legal boundary between state policy and criminal law was breached. Dr. Manmohan Singh, a former Prime Minister of India, was summoned by a special court to stand trial as a criminal accused for an administrative decision made during his tenure. This summons was the peak of the Coalgate scandal, a controversy involving the allocation of national resources, specifically the Talabira-II coal block in Odisha. The administrative fallout was immediate. A pervasive fear gripped the Indian bureaucracy, turning government ministries into graveyards of unsigned files. Officials refused to exercise discretion or take risks, fearing that honest policy choices could lead to prison sentences. This creates a difficult question for the legal system. Was the Talabira-II allocation a genuine criminal conspiracy, or was a complex macroeconomic compromise mistakenly treated as a crime by a rigid investigative framework? Resolving this distinction is critical. As every policy trade-off is subject to criminal prosecution, the state loses its capacity to manage its natural wealth and govern effectively. In 2005, the Talabira-II block was at the center of a dispute between a public sector utility, NLC, and a private manufacturer, Hindalco. Both companies argued they were the most deserving candidate for the resource. The Chief Minister of Odisha, Naveen Patnaik, intervened by writing to the Prime Minister's office. He argued that the private aluminum project would generate more employment and long-term wealth for his state than an independent power plant. The PMO responded with an administrative compromise, a joint venture. They forced a 70-15-15 equity split, allowing the private manufacturer to participate without displacing the public sector's interests. This compromise was upended by a 2012 report from the Comptroller and Auditor General. It claimed that by failing to use competitive auctions, the government had allowed private allotees to gain a windfall of 1.86 lakh crore. But the audit relied on a specific calculation flaw. It applied a national average cost of mining to every block in the country. In reality, the cost to extract coal varies significantly depending on whether a mine is a shallow open pit or deep underground. By using a flat average, the audit created high theoretical profit margins that didn't exist for most specific mines. This methodology transformed a debatable policy choice into the public appearance of a historic financial scandal. The Central Bureau of Investigation spent years probing the Talabira-II allocation. They scrutinized the bureaucratic paper trail, but found no evidence of bribes, financial kickbacks, or criminal intent. Based on this total lack of criminal evidence, the CBI filed 2 consecutive closure reports, formally recommending that the case be dropped. However, the trial judge rejected both reports. He opted to prosecute the former Prime Minister using an unamended section of the Prevention of Corruption Act that penalized decisions made without public interest. The court's logic was that any decision favoring a private entity over a public utility was inherently against the public interest. By this standard, a policy trade-off became a criminal breach of trust, even without proof of a bribe. This created a standard where the basic functions of economic governance were criminalized, equating the accommodation of industry with inherent corruption. On July 29, 2026, the Supreme Court finally issued a definitive ruling. Although Dr. Singh had passed away in 2024, the bench chose to rule on the legal merits to address the findings of the trial court. The court clarified the rules of criminal procedure. A judge cannot substitute an investigator's lack of evidence with judicial assumptions. Rejecting a closure report requires compelling evidentiary reasons, not just a disagreement over policy outcomes. The fallout of the coal scandal also triggered systemic changes. The discretionary committee model was scrapped in favor of transparent e-auctions under the 2015 Coal Mines Act, ensuring revenues went directly to the states. A second reform arrived in 2018. An amendment to the Prevention of Corruption Act now requires police to get prior government approval before investigating a public servant for their official decisions, protecting honest officers from arbitrary prosecution. The 2026 verdict cleared a former Prime Minister's legacy and legally re-established the boundary between an administrative misjudgment and a criminal conspiracy. It provided the legal clarity necessary to finally end a decade of policy paralysis in the Indian state.